There's no timing. There's no timing. Yeah. Let people off after, well, for each individual, just give them each 2 minutes. So, yeah. It's a... All right. Good afternoon, everybody, and welcome back. We're going to go ahead and get started. All right. If you like the debate and the energy that filled the room with, you are going to love this panel because it's going to be a raucous, rock'em sock'em affair. We call this Crossfire format, and the way that works, if you've ever seen Crossfire, is I'm going to present an issue. Many of these issues are things that have already come up today, but we're going to give other panelists a chance to give the definitive word on it. And normally what will happen is I'll say the issue is, and 2 or 3 panelists may comment. Hopefully you'll debate each other or take issue with what each other say. And we will be doing that for about an hour. And then the last half hour, we'll have you guys come up with the issues to present. So it's going to be very interactive. This panel goes from 3:15 to 4:45, so it's an hour and a half. It's one of the longer panels, but we have so many people up here. That is followed by a half-hour panel where we open the presentation to you all to discuss the issue of was the Dujail trial the trial of the century based on what you know and what you've heard today. So that's what we have left to look forward to. You've met most of the people up here. There are 2 new faces. Next to Cherif Bassiouni is David Crane. He is no stranger to our law school. He taught at our summer abroad program this last summer. He gave the very prestigious Klatsky Lecture 2 years ago, and he is best known to the world as the chief prosecutor of the Special Court for Sierra Leone, the first American to be a chief prosecutor of an international tribunal since Nuremberg. And next to David Crane, where did I hear that? Next to David Crane is my good friend and colleague, a very prolific writer, one of the rising stars of the International Law Academy, Mark Drumbl from Washington and Lee. And he has a new book coming out with Cambridge University Press, which I've just reviewed. And I've said amazing things about it, and I'm sure it's going to win book awards this year because it's one of those things when it lands on your desk, you just know that you're reading something that strikes gold. And so we're great to have you here. And then we have, of course, Cherif Bassiouni returning, Mark Ellis, Sandy Hodgkinson, and Bill Schabas. So we're going to have an exciting panel here. And basically the format is I'll ask a question. Anybody who wants can jump in. You have about 2 minutes to answer. Then other people chime in. We'll try to keep it to 3 responses per question. Have a whole sheet of questions. And we'll see how it goes and for the first hour, and then we'll open it up to questions from you all. All right, so the first question I have, the issue is, should a foreign judge have been added to the Iraqi High Tribunal bench? As you all in the audience know, the statute of the Iraqi High Tribunal, which you have in your books, says that a foreign judge or judges can be added. And many people today have suggested that that would have been a solution to many of the problems. I leave it to our experts today to comment. Professor Crane.
Yes, absolutely. It would have assisted in unfortunately, the burden of legitimacy. I think it would have been very helpful to have it. Oh, I'm sorry. Yes, absolutely. I think it would have assisted in washing away some of the real challenges with legitimacy. But if you had a distinguished international jurist or 2, I think it would have helped greatly.
No, absolutely.
All right.
And just to be a little controversial, as you suggested, my answer would be, if I were an Iraqi, I would say, you have tampered enough with our legal system. Let us run our tribunal. This is our business. These are our crimes, and quit meddling with our laws and our legal systems and our procedures.
Mark Drumbl.
I guess one thing is important for us to think about is, although we often consider international judges neutral or credible or legitimate. It's not always, and we take that as implicit. I don't always think that's explicit in terms of populations on the ground whose justice is being meted out to them. And one of the problems with the ICTY to some extent is that, and the ICTR as well, is that these putatively neutral international institutions on the ground are not perceived in that regard because the member states from which the judges themselves come were not viewed as being neutral in terms of preventing the conflict that actually occurred in those two jurisdictions. And by logical extension, I would say that when it comes to the Iraqis, the perception of the international community is not one as a proxy for instantaneous legitimacy. So I think we need to be a bit modest and mindful of that.
That sounds like a lawyer's answer.
Mark, do you want to answer that?
Yes or no?
Well,
No.
yeah, no as well, but for the reason that international law is moving in the direction of requiring national station states to undertake these trials. We need to get used to that, and we need to provide, as part of the international community, support for domestic trials to exist and to meet international standards. That's where we've failed here.
Sandy?
And I would simply add a qualified no in the sense that it obviously is an Iraqi decision, and they put that provision in there for the possibility, wondering if there would be qualified candidates who would offer themselves up for the process. One of the challenges you do face, though, when you start accepting international judges includes issues like translation. If they weren't an Arab-speaking judge, for example, understanding the tradition. So throwing one judge into a panel, for example, may actually pose some of those challenges they're facing in Cambodia, for example, right now, where the mixed tribunal of judges, when they don't speak a common language, poses some challenges. But obviously it's an Iraqi decision. They chose to use international advisors, and international advisors have played that role in trying to build the legitimacy, and they should have more of them.
David, do you want to try to rehabilitate your position?
No, I actually don't really disagree with what was saying. I mean, certainly, at the end of the day, it's for and about the victims in the country. And so, having been through that in Sierra Leone, I mean, I implicitly agree with that. But again, the tragedy in some ways of the IHT, if it's a tragedy, it's not that it's not working or that people aren't working hard. It's just that there's this little sword called legitimacy, and I just threw that out there as, yeah, I mean, it may have. The question was, could it have? And the answer is, yeah, it may have. And I don't say, I'm not backing off on yes. It's just that, yeah, certainly all these points are correct, and plus we want to get this thing going.
Cherif, the final word?
You're talking like a lawyer. It occurred to me
I can't help it.
There was a nice biblical story, about maybe if you could find one righteous man, you'd save you'd save Sodom and Gomorrah. And my question is, how many righteous judges in the various international tribunals that you would set up to a high standards that you would want to offer to the Iraq tribunal?
Oh, see, that's not fair, Cherif. You and I were chatting about this over dinner last night, and you kind of know my feeling. The Achilles heels of any tribunal, whatever it's an internationalized domestic court or a hybrid international war crimes tribunal or an ad hoc war crimes tribunal, let's be honest, is that it's the judges. We have judges who are distinguished, very experienced, all the way down to people who need help getting to the men's room and everything in between. And we had very much a problem, and in where I was in West Africa, and it was a problem. Yeah, we have to standardize how we train and how we deal with international judges. So you're right. I mean, I said yes, but yeah, where we'd find one other than yourself. How'd you like that for a plug? Huh?
I like that.
Okay.
Talk about lawyerly.
Yes. Hey, I'm tapping some here. Let me tap.
But I do speak Arabic.
At the risk of totally violating the ground rule I set up that only 2 or 3 people would respond, Bill Schabas, you can have the final word here. That's right.
Well, I just want to back up David, because David's point was that there is a problem of legitimacy with the judges, and I think that's a valid point. And the idea of international judges, of course, with the consent of Iraq, because it's an Iraqi tribunal, might have done something to resolve that. I feel, people like yourself, Mike, and Mike Newton and others who've done training with the judges, and say you described your evolution and how you got more and more confident about them as you got to know them. And I'm sure that that's true. I'm sure that among the judges there are very devoted jurists who want to be fair and reasonable and everything. My concern is not with the ones who are left on the bench, it's the ones who've gone. And I think that was the point that Mark Ellis made this morning, and we still haven't really, the debate, frankly, fudged it, and people talking about the fairness of the trial haven't tackled that one head on. But when you look at this trial internationally, the part of it that smells the most is the fact that you've had 3 judges leave for various mysterious reasons, and we couldn't even get clarity on this most recent case. And that's shocking. This is supposed to be the brains trust of the Iraqi justice system. We're supposed to know everything here, and we can't even agree on why that judge lost the job. And when did you last have a trial in the United States when 3 judges departed in the course of a trial? That's what's so terrible about it, and that's where the problem is.
Well, Bill says that was the biggest issue. Probably the biggest issue in the minds of most people wasn't the judge's changing of the guard, but the assassination of the defense counsel. So the second issue is, what should the IHT do to better ensure the safety of trial participants, especially defense attorneys? Before I open it up, just a word of background. As you probably heard snippets today, what happened was 2 defense counsel died the very first week of the trial when they were assassinated. Before that happened, both of those defense counsel and all the defense counsel were approached by both the United States government and the Iraqi government and asked if they could provide them security. And also, it was suggested that they don't show their faces on television. Now, the defense counsel wanted to show their faces on television, talk to the media, and they didn't trust the U.S. government or the Iraqi government for security, so they turned it down. I think the U.S. government and Iraqi government's response was metaphorically, well, that's your funeral. It turned out it was. After the 2 of them were assassinated, Judge Rizgar Amin brought all the defense counsel in and he said, look, we've got to solve this problem. We can't have defense counsel dying anymore. They worked out a compromise, and under the compromise, money was given to the defense counsel to hire their own personal guards, personally selected, who were given the authority to carry weapons and protect them, like rock stars or football stars would have. That seemed to work pretty well. Nobody else died for the 8 month of the trial until a week before the closing arguments when a 3rd defense counsel was assassinated. Strangely, there were no security guards there at the time that defense counsel was assassinated. I have heard 20 different stories about why that is so. The one I tend to believe is that he pocketed the money and did not hire security. But I'm not sure exactly if that's the case either. It's just not been answered definitively in the press or anywhere. But clearly there's a problem. You can't have trials when you have 3 of the 12 defense counsel being assassinated during the trials. Everybody agrees with that. So the question is, what should the IHT do in the future to better protect the defense counsel? Anybody? Mark?
Well, I think what I'd like to do is take your question and unpack a broader point. Something has been going on here all day that has troubled me to some extent, and it's an assumption that we've all labored under, and it's assumption that we've all internalized, and I guess it's normal because most of us in the room are lawyers or soon-to-be lawyers. And I think one of the problems with the trial is that there was a rush to trial, in a sense, insofar as obviously there's security problems now because the country is not stable. And one of the reasons the country is not stable is because of security concerns. And when I say rush to trial, I mean the following. We have placed so much hope, ambition, aspiration, meaning in this set of prosecutions. We're calling it the trial of the century. We're really, we're really very grandiose about this trial. And a concern that I have is the following. We've taken this ambitious approach. We've internalized it. We've had a rush to trial. We're going to keep on trying. We're going to keep on moving forward. But at the end of the day, I think one thing we need to be sensitive about, and this is heretical in a sense in the community of international lawyers, but I think we need to accept the fact that trials in law can only do so much, right? There's a very limited potential to criminal prosecutions as an element of social transformation. And I think had we had more modest and more honest understandings of that at the beginning some of this ongoing discussion we're having now, namely, how do you prosecute during, a situation of insurrection, we wouldn't have had this conversation because maybe we wouldn't have had this rush to trial. So I just want to throw that out as we've had all this talk about, is the trial on the side of due process or not, or it's been a very self-referential conversation. And I wonder whether we might want to have a conversation outside of this, apparent transformative potential of this prosecution.
Sandy?
I would simply like to comment that I'm not sure there's much more you could do in the current environment. The counsel were brought in. They were asked what is it that could be possible solutions. They were provided a bunch of solutions, including housing in the green zone. I've been there. I've walked through it. They choose not to live there. It's challenging. They come in country to meet with their clients, but they say they can't come into court. So as far as what you could do, short of stopping the trial or short of moving it outside the country, in this situation they've got in Iraq, I think that the IHT has done the best that you could possibly have, including the appointment of IHT standby defense counsel to ensure a full and fair defense for when the defense counsel choose not to come.
Well, then, should they have considered moving the trial outside of Iraq?
Well, again, I would say no, because, again, the decision was made by the Iraqis to have a trial in Iraq. International law favors that if there's a competent court, they're willing and able to do it, then they try to do it there. Obviously, here, there have been significant security issues that have risen up. It's posed a challenge. They've tried to modify the procedures and give more time to defense to put these measures in place. I think they've taken the appropriate and reasonable steps in line with moving forward on trials that they're expecting to move forward on.
Let me ask the experts, how different is the security situation and the challenges than trials of major terrorists in Europe or Latin America or elsewhere, of major narcotics dealers in Latin America, of major mafioso in Italy or in New York City? These are all places where during trials witnesses disappear or die, defense counsel, prosecutors are executed, judges are bribed, and yet they seem to soldier on most of the time. Is this really a huge difference in degree here in Iraq? Yes, Cherif?
Yeah, a few of us here, Sandy, Christopher, Mike, have been in Iraq. I continue to go there. Frankly, the situation outside the green zone is really quite dangerous, particularly for somebody who is going to be identified as a foreigner. This is not only a question of a conflict with different ethnic or religious groups. You have a very significant common criminal element that is working the streets. I mean, Saddam released an extraordinary large number of people, estimated about 80,000, 3 weeks before the invasion. We don't know how many of these were hardcore criminal. They could be 20, 30,000. Unfortunately, the coalition forces didn't have the resources to deal with them as a common criminal element. They've had time to consolidate. They have all of the characteristics of organized crime units. Now, if you had a tribunal, preferably, ideally, outside the green zone somewhere, the problem is in a tribunal like that, you just don't have a few limited people who are coming in and out on a daily basis. You've got a very large number of people, whether it's people providing food or supplies or paper or whatever it is, in addition to the defense counsel, the judges, the prosecutors, the investigative judges, the support personnel. It's very difficult to be able to ensure protection, even though you may want to create a sort of an island, fortress type, like the green zone somewhere else. It would seem to me that it would be almost impossible, because you're dealing with so many different sources of danger that you cannot identify. I mean, if you're dealing with the mafia or the Cosa Nostra, you know who they are, where they're coming from. Here, you've got too many people out there, you don't know where they're coming from.
Security is security. I mean, it's all about security, whether it be in Iraq, Sierra Leone, Bosnia, Rwanda, what have you. It's security, security, and security. I think security is going to, despite all the hard work of the people that are working there, it's going to consume this tribunal. I mean, it'll come to the point where, because of political events that are totally out of their control, it may totally absorb the hard work that is being done, and That's unfortunate because, again, people, instead of soberly thinking about law and fact, they're looking over their shoulder whether I'm going to live to the end of the day. And that's not the point now, but certainly security is going to be a huge problem. I mean, we can look back and say, well, if they did it this way, then this would happen. We're not at that point now. It is what it is, and security could very much consume this entire tribunal, sadly.
But will it taint the final conclusion on whether or not the trial met international standards? The sense of we've either lowered or probably lowered the bar now. If for any reason the conclusion is, yes, we kind of got through this whole process. Was it perfect? It wasn't perfect, but we have a verdict here. And by the way, we have 3 defense counsel who were murdered. I have a difficult time understanding the defense to a fair trial when in one trial you've lost 3 defense counsel. That's something, I don't know if we have faced that yet in an international context, but it will be curious how history judges this, and it will certainly be a different bar now for future trials, good or bad.
As a follow-up, ask Bill Schabas this question. If this was a case that was within the jurisdiction of the ICC, so for example, if Iraq had been a party to the ICC, as the ambassador had said he supported, and Iraq decided to prosecute itself under these circumstances with this kind of assistance, would this be a case that the ICC would likely find the country was actually unable or unwilling, certainly not unwilling, but unable to prosecute under these circumstances?
I think probably, I think that the ICC wouldn't intervene in such a case. I think that we've had this discussion. Many people have said, we're not talking about a sham trial. And we're also talking about a trial, incidentally, where, in all likelihood, there's going to be a conviction and the man is going to remain in jail for the rest of his life. And so it's not something where you're saying there's an impunity problem, exactly. So I think it's unlikely that you'd see any intervention by the ICC. This isn't the worst trial in history. I mentioned the one of Pol Pot and Ieng Sary, which was a really ugly business that they had. There were trials of the Gang of Four, weren't there, in China? I'm sure they weren't models of great justice. But this isn't, it's not the Eichmann trial either. That's the point. This isn't one of the great trials of history either. It's somewhere in between. It's deeply flawed. But I don't think we have to dismiss it as being a sham and a travesty of justice. But I wouldn't put it on a pedestal either as one of the great moments, what did you call it, the Grosjean moment, or the trial? Thank God the century is only 6 years old, because if this is the best we're going to get in 100 years.
Let me...
Can I say one thing, just because, somebody mentioned the word negligence, and the death of the defense counsel is something that really hit everybody working on this case very hard, and we all took it very personally, and I can tell you that when the defense counsel the first 5 or 6 times refused what they were being offered in terms of security, we did not say, well, that's your funeral. Right. I sat in a room with translators and with other prominent Iraqis who I thought could help convince them, and we called every single one of them personally and begged them to accept the security measures that we were offering. And, in the United States, if the U.S. Marshal Service is protecting a judge or someone else, it's take it or leave it. You do it their way or you're not getting the protection. And if you don't like the fact that they're going to bring a dog into the, to search the room that you're going to, that's tough. You either accept their protection or not. In Iraq, we were very flexible. We were bending over backwards. And to my surprise, even the Iraqi Ministry of Interior was bending over backwards because they knew what a disaster it would be, how difficult it would be if one of the defense counsel were killed. But so the question is, what do you do in this case? You can't say, well, we're not going to have a trial because it's too dangerous. And moving out of the country doesn't solve the problem, because an Iraqi defense counsel living in Iraq, whose family is in Iraq, is going to go back to Iraq. And you're going to have the same problem of whether they're going to comply with the security arrangements or not. And so this issue, unlike some others, really doesn't go to the issue of should it be in Iraq or shouldn't it. It's, well, can you have a trial at all? And if you do have a trial, you can't kidnap the defense counsel. You can't make them accept security.
You're saying, well, you can't say you can't have a trial because of security issues. We've lost 3 defense counsels. Let's say we lose the 4th. Does it stop there? If we lose 5, does it stop there? Where does the standard? Somebody has to question the legitimacy of the entire process if something as fundamental as losing, in this case, 3 defense counsel or the 4th defense counsel. I'm trying to get a sense of what's the measurement. Where do we then say?
Get a sense of, because we're dealing with not just sort of a philosophical issue, but a real world issue. Is what do you do? What do you do in order to have a fair trial? Because you've got to have a fair trial. I mean, I think that's right.
Let me throw out a suggestion for a second.
And you can't kidnap people.
Let me throw out a suggestion and get the panel's views on that. When the ambassador came, I was asked if he was coming with his own security, and I said no, he didn't think there was going to be any security threat in the heartland of the Midwest. He was coming by himself. And they said, other people said, well, I bet diplomatic security at the State Department will be following him around from a distance. And that got me thinking, what about the idea of passive security? If the defendants don't want security, or if they're pocketing the money that they're supposed to be spending on security, couldn't you give them security that just kind of follows them from a distance, but is there in case there's the kind of attack that occurred 2 weeks before the final judgment? Would that work? What are the problems with that?
Well, it's just a practical point. Farther you get away from the principle, the chances go up almost exponentially as to what could happen. It's almost a waste of time in some ways. I mean, if they want to do it, it's tough anyway, but it becomes tougher to protect if that becomes more of a background security.
Bill?
Yeah, I think we're getting off the track. First of all, we're not experts on security. We're lawyers, you know, and I don't want your advice. If my life's in danger, frankly, with all due respect, I don't really need your advice. I'm going to get a professional to advise me, because I don't know what to do. But I also suspect that, I mean, the 3 who were killed, they're our colleagues, you know, they're fellow lawyers, and I would assume, I'd give them the benefit of the doubt that they were using their best judgment on how to protect themselves, that they weren't doing crazy things. I don't think it's good to be speculating about them pocketing money and saying that, you know, we offered them protection. Okay, so we offered them 3 U.S. Marines with submachine guns. I'm not sure that that's the way to protect my life either, walking around. You know, like I'd assume that they used their own best judgment to do what was best to save their lives, and they got killed anyway, and that's terrible, but I don't know how to avoid that except maybe to sequester a trial, the whole thing from beginning to end.
Sandy?
Can I just add it real quickly? I mean, that was the point, though. That was the point of spending all the money on building them actual housing within the green zone right next to the court by a law library where they could do everything, meet with their clients. That was the purpose, was to sequester it in a safe place. But I think, and this may not satisfy a lot of people because it's a generalized security issue, but it's sad but true that in Iraq, IHT judges are not the only judges who've been killed. And so the question is whether they're being targeted because they're related to this tribunal, whether they're being targeted because they're judges, which others have been for that very reason and in greater percentage, in fact, or counsel and the same, defense counsel, or whether it's simply that some of them were unfortunately victim to random violence. And while we'll never know for sure, they've obviously tried to look into these facts, but they've never been able to really ascertain notes that have said, yeah, I killed this guy because he was defending Saddam. There isn't been that kind of information to let us know. So I just sort of flagged that as an issue.
We'll expand the panel momentarily because Nihal and Kevin both want to chime in. So can you?
Pretend I'm Ken Roth. I wish I was that.
Do you have a microphone so that?
Do I have to stand up? I mean, if people can hear me, I'll just stand up.
No. But we're transcribing this and recording it. We need that. So.
Yeah, I just wanted to add sort of a few factual issues. And again, I think following up on Bill Schabas's point, I mean, you know, I take Chris's point that from the point of those of us who were there when Sadoun al-Janabi was killed, and actually it was 2 weeks later when Adil al-Zubaydi was killed, not on the same day, you know, it's hard to understand why they wouldn't, for example, move into the green zone. And we asked them when we met them, you know, in a hotel in Baghdad, why don't you do that? And they said to us, well, first of all, you know, we have legal practices outside in Baghdad. You know, this is not the only trial we're involved in. So we don't want to move into the green zone because that makes it effectively impossible for us to do our job. So that's what they say. The second thing they say is, you know, well, we think the people who killed Sadoun and Adil were people who work in the Green Zone in the Ministry of Interior. Now, you can call that paranoid, but from what we've learned about what the Ministry of Interior has been up to in the last 6 months, it's not entirely off the wall. Right? And the third reason is, which I think a reason we should also respect as colleagues, they say, what's it going to do to my credibility to be living in the Green Zone, the seat of American power? Right? So that's 3 reasons that they gave us. Now, we can accept or reject those reasons, but they're not ridiculous. You know?
Kevin, do you want to add anything?
Yeah,
Microphone. There it comes.
Yeah, I guess this is the first part of the day that gets my kind of criminal defense hackles up. But they're criminal defense attorneys, and they are part of the system, but they are not part of the system. And I don't understand how you could be expected to have credibility as a defense attorney when you're being protected by the Americans. And it's not a comment on the legitimacy of the invasion. It's not a comment on the legitimacy of the tribunal. It is about professional independence and autonomy and credibility with your clients, with the defense bar, and with the rest of the world. And living in the Green Zone would be impossible. And I don't think it's a criticism of the tribunal's existence to say perhaps the security situation was not such that you could have the trial this quickly. It is not saying there's anything wrong with the trial. It is simply saying the security is too bad for reasons beyond anyone associated with the IHT's control to have this kind of trial right now in the middle of Baghdad. So,
Hamis al-Labadi came to interviews with us with his child.
Nihal, we can't do this without the microphone.
But I really do think it's outrageous to suggest that he put that money in his own pocket. He had 4 children at home. He was staying in Baghdad to the end of the year to try and get them out of the country after that. But I really don't think that's acceptable. I'm sorry. I think that's an insult to him and it's an insult to his family.
Okay, but I was just saying that we don't know the reason, and that's one of the things that's been speculated about in the press.
Well, if you talk to the defense lawyers, you might get some perspective on the reason.
Okay. Well, thank you. Mark, I'm going to let you have the last word on this second issue of the 20 that I was hoping to cover, and we are now halfway through our time. Go ahead.
The question that I would just ask is, it's very valuable for us to ask ourselves, is this trial conforming to due process? And not. I think that's a tremendously helpful exercise. But for me, another very important question is, what is the relationship between this trial and peace and stability in Iraq as a whole? And that's not a question that we've really asked ourselves today. And I think it's a very important one. I agree with Bill. We're not security experts. But this isn't a question of, day to day, how to keep myself safe, ourselves safe. It's a broad question that really it should be at the forefront of interest for international criminal lawyers, namely one of sequencing, when is the right time to have trials, and if trials create peace and stability, that's good. But what if, in the Iraqi context, and we haven't talked about this today, there's an inverse relationship? What if there's a relationship of instability derived or derivative from this trial? Then I would be very worried about holding that trial right now in whatever zone you might want to have it in Baghdad.
Professor Bassiouni?
First, let me lay a foundation to answer your question, and I don't mean to be self-servant, but for 3 years that I've been working in Iraq, we have had 6 conferences with law professors and judges, and maybe involving a total of about 600 people. I've had all the judges in Syracuse for 10 days. And we've done a lot of work. Presently, I have 66 people working in Iraq doing an oral history. We have interviewed 2,700 victims so far. And I can tell you there probably isn't an Iraqi, at least that I can imagine, that would not want justice in a broader sense, that would not want the truth to be known, that wouldn't want all of these people in the Ba'ath regime, and not only those major defendants, strung by their toes. So there's no doubt that this is very much a need. Every one of the different constituencies, in particular the Kurds and the Shias, want very much the story to come out of their victimization. They want to show how bad the regime is. And frankly, I think the majority of people that I have dealt with are disappointed with the trials. They don't think it's bringing out the truth. They don't think it's showing these people the way they really were. They don't think the proceedings in any way resemble what they imagined or anticipated. They really see Saddam as running away with the show. They're largely disappointed. But as Bill Schabas said, is the glass half full or half empty? You know, the mere fact that you've got somebody who is able to point at him and to speak for a few hours after and say, you have committed thus and so. And I can tell you, people in Kurdistan who can say, well, you know, here is a witness who is testifying. I mean, the entire people of Kurdistan is the cheering gallery for it. So the wrenching problem, I think, is really what Ken Roth said. We should have been speaking about all of these terrible crimes. We should have been conveying to the people the sense of justice. And unfortunately, we wind up quibbling about, is that a proper law and did the procedure work out right? And that's the unfortunate part of it. And maybe more unfortunate is, had we given that more thought before we set it all up, and had we tried to play out all of these contingencies and try to mitigate the damage, we wouldn't have been in that position. But we're now trying to mitigate the damage as we're proceeding. But there's no doubt that the people really want justice in any way, and they want to have a record of these terrible violations that took place. And for them to think that all of this is sort of now bound in a quagmire about procedures and processes and antics in the tribunal is adding almost insult to injury, I think.
Let me ask a follow-up that Nihol's comment got me thinking about, and that is, would it make sense to have an international investigation of the assassination of these defense counsel, like the international investigation that is ongoing with respect to the assassination of former Lebanese Prime Minister Hariri? Anybody want to comment on that?
How the hell would you do that, Mike? When they walk the streets trying to find out who did it, half of them wouldn't come back. It boils down to security again, despite the. It's an interesting. Whoop.
Yeah.
I'm trying to be too informal here. How would they do that? I mean, it's an interesting idea, but how practically would they do it? Even if the U.S. or coalition forces gave them full protection, it would almost be impossible. How would you do that? I mean, I'm just throwing that out. I'm not sure that's practical.
What's the alternative? Just to turn your back on it and not investigate it? Or,
well,
or allow the people to investigate it that are accused of committing
We have to live in the real world. I don't think you can do any investigation.
Ever?
Well, I'm not so sure. I mean, when the dust settles, maybe someday, but right now I don't think you can do it practically.
Okay. Sandy?
I would just add, I mean, there have been investigations into it. The question is whether or not you think the brokers are credible, whether they're the Iraqi government or the Americans looking into it on their behalf at their request. But the independent investigations haven't moved at such a tremendous pace in the past that I would have reason to believe that they could be achieved in a time to really impact what's happening in the trial. And so that's, I mean, I think on practicality grounds it probably doesn't make sense. But certainly it's been looked into by the Iraqis, by the Americans, and again, there hasn't yet been any reason to be able to definitively link that they were targeted specifically because of their role in the trial, et cetera. But
a couple of comments on this very issue from the audience. I saw Marika's hand up.
It's not on this issue.
Oh, okay. Well, let's wait then. Is this on this issue? Yeah.
I'm unrepentantly committed to domestic trials. That said, and thinking about what we're presently talking about, is there any reason why a domestic trial has to be held in the territory of the state? And I know a little bit about the Lockerbie trial, where, not for security reasons, but for other reasons, namely securing the surrender of the two Libyans for trial, a Scottish court applying Scottish law and Scottish procedure with Scottish lawyers sat in the Netherlands for 9 months.
I should mention John Grant, who is a professor both from Scotland and the West Coast, who has been a speaker at our conferences in the past and is the author of a great book on the Lockerbie trial, really knows that issue, and it's an interesting analogy. Does anybody have a thought on it?
I mean, I think a quick answer is there's no reason why it can't be. I mean, it was the Iraqis' desire to have it in Iraq on Iraqi soil. That doesn't mean it couldn't change at some point. It simply just needs to be acknowledged that when you move it to other places, particularly if you're looking at The Hague, the cost does go up exponentially, and that's a factor for the Iraqi government and for other donor nations. I mean, the cost of trying Charles Taylor will be significantly higher at The Hague than it will be in Sierra Leone, but it's precisely for that reason that there was a decision to at least move the chamber to sit outside of Sierra Leone. So yes, it's possible, but it would, again, have to be the Iraqi decision with their consent.
Let me change tacks and ask a brand new line of questioning, which I'm sure is going to get everybody else going, and that is this question. Was it a mistake to begin with the Dujail case rather than Onfall or another case, especially in light of the fact that there is the possibility of the death penalty?
I was among those recommending it to the judges, and I thought that this was the ideal case to start with because it was a case that didn't have any political dimensions to it. This was not a situation where the defense could raise the argument of you received intelligence information from the U.S. or you received the precursors from the UK or Germany or the Netherlands. This was a fairly straightforward murder case, and so there were no political ramifications to it, and so I think it was really the ideal case to proceed on because it was on very narrow technical grounds, and all of the documentary evidence was really there from the record of the Revolutionary Court that went through the decisions and then Saddam's approval of the death sentence.
Bill?
You've got to the heart of one of the problems with using the death penalty there, because if he's executed, probably in the next 6 to 8 months, you're going to deprive the people of Iraq of justice for all of the other crimes. And there is a suggestion that he's sort of the private property of the people of Iraq. But there are other victims as well. Iran would love to have a little crack at him, I'm sure, at some point. In fact, they've asked for him, and they're going to be deprived of justice. They should have an Iran trial as well. Maybe have it in Iraq, but you should be tried for the crimes he committed against the people of Iran and the people of Kuwait. And all of that, with this hasty trial on a very focused, narrow indictment, is followed by the death penalty, is going to give a few people satisfaction, but it is going to, we say now it's a fundamental human right to know the truth and to have justice, and there are going to be a lot of people who will be deprived of that.
Bill, you amend the statute and you don't execute the person 30 days after the date of entry of judgment, or you withhold the entry of judgment until all of the trials have taken place, when you enter it 3 years from now. So one doesn't exclude a remedy there.
Mark?
I think for the audience, the issue here to clarify is that under the statute, if the trial chamber were to convict Saddam Hussein and then sentence him to death, that appeal would automatically go to the appeals court, the Court of Cassation. But after their final decision, assuming they uphold the verdict, then that sentence has to be imposed within 30 days, and that's the conflict within the statute. Having said that, I think that administratively, logistically, they'll kind of figure this out as to how they can come up with the Dujail verdict and at the same time move forward with the Onfell case and any other cases. I think they're wrestling with this right now, trying to figure that out, which is why I do believe that the Onfell case was, the Dujail case was the correct approach, a case that was manageable, not as complex, certainly in relation to what we're seeing now in the Onfell case. And I had great hopes that once the Dujail case was over and they moved to the Onfell case, which was, of course, the most complex case, I think, that they would have resolved all these issues. Of course, the lingering problem is still, as I said earlier, government interference, which is existed in the Dujail case and exists now in the Onfell case.
Mark?
I guess, regardless of one's concerns of sequencing or the effects of trials, I do agree that in this case, people want to see justice done, and that probably the most valuable aspect of this trial is a bit of a truth-telling and legitimizing the historical record. So one concern that I would have, even if a death sentence were suspended with regards to a verdict in the Dujail case, is, the subsequent trials, what would they seem like if they were trials of a man who already had been convicted of something? And I don't know whether that alone would have an overall effect. I would suspect that it would not have such a detrimental effect, but it's something that I think we need to think about. And I think this ties into a broader question. I mean, I think one of the reasons why the Saddam and the prosecutor's focus in Iraq is on these mini trials is to avoid the sort of blockbuster, all-encompassing, very long trial narrative that came out of the Milosevic proceedings, which we all know how they ended in a very unsatisfying way. But I think there's dangers with mini trials as well, and the question I would ask is, does the sum of the mini parts sort of add up to an overall narrative of what actually went wrong? I think it can work in that regard, but I think it's something that the folks associated with the tribunal need to be sensitive to.
I'm going to go to Marika, then Sandy, and then David.
I wonder if the speakers could reflect on whether, of course, originally Saddam wasn't part of this trial, and he was added at the very last minute. Could you reflect on whether that was really such a good idea? I think we've been talking also a lot about the fair trial rights of the senior defendants in this trial, but what do you think it did to the fair trial rights of the more junior defendants? And also, in terms of using this trial to start out, I know a lot of us are probably still at the early ages of analyzing the evidence, but I think there's, as Professor Bassiouni said, there's not a very clear narrative perhaps that emerged through the evidence from this trial in terms of, there were just facts that were confusing, an assassination attempt, the Dawa party, all these kinds of things. So in light of that kind of convoluted history and then perhaps a prosecution case which may not have been as strong as it should be, where do we think we stand on whether it was really such a good idea?
Before we go to your two issues, does anybody want to answer that directly? Sandy?
I can take it with the answer
Okay.
I was going to give. I was going to just add two quick footnotes, really, to what everybody else said, because I think Dujail was the right trial to start with to try to work out the kinks. It wasn't necessarily envisioned that Saddam would be a defendant naturally in that. He might have been, he might not have been, but that's what came out of the investigative process through the Iraqi system. The fact that he was part of it obviously brought up the specter of how much the public was scrutinizing outbursts and other parts. So that weighed against some of the balance of trying to quickly move through a case to get sort of a quick one under the belt and work out the kinks of the system. But so that's part of the issue. The second one, though, is to whether or not, if he is in fact executed based upon this first case, which I suspect, we'll all see the Iraqis find a way to work this out somehow in their system correctly. What is important to remember is there's a lot of other defendants who are responsible for the other major atrocities that they want justice for. Chemical Ali, for example, for the Anfal. And there are other defendants. So despite the fact that other trials may go forward long after he has had his sentence carried out, whatever that may be, there are other people that are still to be held accountable.
David, did you want to chime in on this? Or?
Well, I was just thinking, I think Marika brings up an interesting point. With Saddam Hussein standing and doing his grandiose, which he tends to do, you look in the background, there's a whole bunch of other defendants who are really bad dudes, as we say in the law. I keep forgetting about this, Mike. These are bad guys. And, what we did in Sierra Leone and what you guys are doing in Iraq is put bad guys in jail, and that's what you do for a living. And but what's going on with the background of these other individuals? We tend to all focus on Saddam Hussein, but you're right. You look at several guys in the background sitting in their underwear or their pajamas or whatever clothing that they're wearing, and the question is, are they getting a fair trial or a fair hearing? And two, what they done publicly has been put forth in the international community of the Iraqi people? I'm not sure, because I haven't seen much as to specifically what these other bad guys have done. So I defer to those who were there, but it's an important consideration if you think of the International Military Tribunal. I mean, we knew every one of those, what they were doing. You know, Goring tried to grandstand a bit, and Hess wandered off. But, you know, but we knew what they were doing. I mean, they were all individualized criminals in a joint trial. And my question is the same thing happening with the IHT? I don't know, have an answer. I'm just posing this, and smarter people than mine may be able to answer that. But I think Marika brings up a good point.
Well, to answer Marika's question, and I think it's something that all of you have to think for a minute, I don't know what your frame of reference, that is the whole audience here, is in terms of where do you place Saddam and his regime in relationship to the violations that took place. Because if you understood the evolution of the very repressive Ba'ath regime over a period of 30 years and how that repressive regime worked in so many sometimes devious ways and ways that you may never imagine. We have an attorney who is, I don't know if she's still here, she came out during the break. She said, I'm an immigration lawyer. I represented a woman who was raped by the driver of Uday. You know, we do have situations that do not rise to the level of a genocide, but we have a regime which on a daily basis violated every possible rule that the Iraqi law and society had. And this one was a case in which, you know, Saddam was elevated to a demigod. The demigod was about to be shot, and everybody in the system of security was running like crazy to get before the other in order to show that, you know, they were the good guys who caught the bad guys who wanted to assassinate. I mean, if they would have had to kill thousands of people in order to be able to say, see, Mr. President, we got the people who wanted to kill you, they would have done so. And so it was, in a sense, a very good case to show how all of these underlings did it for him, but ultimately he approved, he encouraged, he supported, he had command responsibility.
Mark, you've been patiently raising your hand there.
Because I think the question is such a great question, because it does point to another issue in the Dujail case of having 8 defendants, 4 senior defendants, 4 lower defendants. And I question whether or not the evidence has proven crimes against humanity committed by the 4 lower defendants. And I really believe that, I mean, my sense is that they have not proven that because of the intent and knowledge requirements for crimes against humanity. And in the end, that may work to the advantage of the court if they find the 4 senior defendants guilty, but the 4 lower defendants not guilty of crimes against humanity. It's not to say they haven't done bad things, but it's an interesting question about the court's decision to bring crimes against humanity, charges of crimes against humanity, against these 4 lower defendants. And I really question whether they should have ever been in the court on those charges. So I think you should watch that as this Dujail
and Mark,
come out.
Mike Newton suggested in the margins that a really good development might be on October 16th when the tribunal reconvenes and it's assessing the evidence but not doing its verdict. It could actually decide to dismiss 2, 3, or 4 of those cases. That would be consistent with what it says it's going to do, and it might be a really nice signal for the tribunal. So if anybody's talking to the tribunal on a regular basis, so you might suggest
But the real question, Michael, is what was the basis for having those 4 defendants there to begin with? Again, my opinion is that the evidence was so lacking for the charges of crimes against humanity. My question is, why were they there to begin with? I could be wrong.
We actually have a debate on our website on this. Our students at Case did a research memo, about 60 pages, on the question of whether if somebody basically turned over a friend or neighbor, knowing that the regime was going to torture and kill them, would that be sufficient to be a crime against humanity if it was done in the course of widespread similar occasions? And apparently the allegations, I don't know if they were proven because it really seemed like the evidence focused much more on Barzan, Saddam, and al-Bandar, but the allegations were that at least 2 of these individuals had been, for political reasons, turning in their neighbors who disappeared forever.
See, that problem would have been solved had we added to the statute and other violations of the 1969 Criminal Code, and we could have gotten these people for murder and rape and torture and whatnot. And it would have been much easier if that would have been the case.
The only and again, the footnote I would just sort of add to that, though, is then you do start running the risk that they will focus on lower-level crimes and try to expand and try too many cases. I mean, one of the add-on specialized Iraqi offenses that are in the statute include squandering of national resources, manipulation of the judiciary, and one which is very significant, which is waging war against an Arab nation. But the other 2 were never sort of intended to be tried alone. They were intended to be tried in conjunction with a crime against humanity or otherwise. Should the court start pursuing a lot of cases for the simple lower Iraqi offense alone, the only problem you end up with is it could bog down the court simply because there is currently only one courtroom and exactly. But I just want to say though that it is important though to find a way to sift out those lower cases and have somewhere they can be. It just may not be in this court.
Let me ask this as a follow-up. When David Crane prosecuted, his tribunal had a clause that none of the other tribunals have, which was a limiting clause. It says that his tribunal was only allowed to focus on the most serious perpetrators. Is that
greatest responsibility?
Those who bear the greatest responsibility, but it's analogous, I suppose, the higher-ups. And there have been debates that if you only focus on the higher-ups, it sends the wrong signal to the lowerlings that you can't succeed as a Saddam Hussein or as a dictator unless you have a sycophantic following, and therefore you have to have exemplary trials at other levels. So I'm wondering what the panel's take is on the fact that they even indicted some of these lowerlings. Was that a mistake?
Well, certainly, just real quickly, obviously you've raised a very important question. That is, what is the level, what's the standard now do we need to, as we move into the 21st century, of creating mandates for future tribunals, whatever they may be? It's my considered opinion is that greatest responsibility should be the standard, because we can't prosecute everyone. We have to go to those who created the conditions by which these situations developed. Greatest responsibility proved to be an effective tool in Sierra Leone and West Africa. It allowed the prosecutor to focus very, very quickly and get started. I'm very well aware of the impunity gap, but the difference between prosecuting 20 people or so and 30,000 is significant and would literally throw the baby out with the bathwater, in my opinion. And greatest responsibility was the political compromise, as we all know, when they were drafting the statute for the special court for Sierra Leone. If it wouldn't have been greatest responsibility, there wouldn't have been a special court. As simple as that.
Other comments on that? Bill?
Well, the judges at the International Criminal Court are, in effect, importing a test similar to the one from Sierra Leone through the use of the word gravity in Article 17, Paragraph 1 of the Rome Statute. And the prosecutor has also made some interesting determinations along those lines. He, for example, is saying that he won't prosecute certain cases where there aren't large numbers of victims. In other words, he makes his choice based on just the calculation of the quantity of victims, which sends an interesting message as well with respect to the investigation concerning British war crimes in Iraq. He said, yes, British soldiers have committed war crimes in Iraq, but not very many. And I guess the legal advisor in Britain now probably has written an opinion to the general saying, keep the numbers down, boys. It's okay. You can commit war crimes, but not too many. That's off limits. So, yeah.
Well, I think it's really important to understand prosecuting 13, 20 individuals is going to take around 5-6 years to do it fairly, openly, and appropriately because it's an international tribunal under international criminal law and the statute. If you change that to most responsible, in the West African situation, it went from 20-ish to 100 to 300. I am looking at, in my estimation, 15 to 20 years of prosecutions. If you just said those responsible, which is really kind of the ad hoc mandate, it would go in Sierra Leone 30,000, and it can't be done. So, in my opinion, just as a way of thinking, is that any tribunal that is in existence over 5 years begins to unravel around the edges and becomes more of a political liability than an assister in stability.
Well, we also have in the audience Professor Linda Malone, who was kind enough to actually serve as a substitute in case anybody dropped out. So that's why she came. She's part of the academic consortium that does work for the Iraqi High Tribunal. And so I'll expand the panel for a second and hear your comment, Linda, or your question.
Thank you for letting me intervene briefly, because there's one issue that I think hasn't come up today, and it would be a shame if it didn't. And I'm very concerned about the relative invisibility of women in connection with the trial so far. And that seems to me across the board in connection with prosecutors, judges, the witnesses that have been women have not really been focused on, I think, in a way that they should have been. Even with commentators, with all due deference to the excellent commentators and media experts that have spoken, Simone's a welcome exception. If you take Ruth Wedgwood out of the picture, and many people wanted to, there really wasn't much diverse representation. And it's not simply an abstract principle of diversity. It is extremely fundamental in this context and absolutely a necessity for transitional justice. I guess I would characterize this as a lesson we haven't learned from this trial that I thought we had learned in Bosnia and Rwanda, but it appears that we haven't. And I know that there were judges, women judges, who were trained, and I don't know where they are. I'm wondering, are they being retained for appeals? Or I would just like to hear the comments of the panelists on this, and hopefully in the upcoming trials we'll see more emphasis on some of the things that have been raised today in terms of the women and children who have suffered so disproportionately. Thank you.
And you, the author of the blog that's included in the book, would probably want to chime in as well on this. So go ahead.
Yeah, of course I agree with your point, having written the essay titled The Visibility of Women in the Tribunal. But you know, what I found interesting about that is my understanding is that the tribunal has heard the message and is going to do something about it. Too late, perhaps, but something is being done. And people like Basra, who appear behind you, and other wonderful women in Iraq and of Iraqi descent are working on that. But what I found most troubling, I have to say, and it's in a footnote, so maybe some of you haven't seen it, is that on April 5th, when the defense lawyer, who is a woman, the one woman, comes in and gets thrown out of the court for the second time, what do the defense lawyers, all male, say to the judge to plea for her to be brought back into the court? Well, Your Honors, you know, women are emotional. So I think that's, and that was said. And to the credit of CNN and Court TV, they did a whole show on that issue of the invisibility of women. But I think that the training is not only the issue of women being included in the courtroom, but the courtroom being made sensitive and friendly to women, so that if a defense attorney says that a judge steps in and says, this is not an acceptable way to speak about women being thrown out of the courtroom. Men are emotional, and look at what you guys have been doing throughout this trial. So that's my only point about that. It's not just the presence of women. I think it's a little deeper issue about the whole culture and the climate. Thanks.
Mike Newton, do you want to add to this?
These are important points, but it also goes to the discussion earlier about the gap between what really is going on and the perceptions and in the marketing and the public dialogue. I mean, the deputy prosecutor in the Anfal trial is the most wonderful, talented, prepared woman that I know there. She's brilliant, and she has worked extremely hard, and I've not even heard that raised. I mean, it's not just been a topic of conversation sort of in that part of the world. And you know, if you're looking for a role model, there she is, but it hasn't been focused on at all. You know, I've had long conversations. She's brilliant, and they're very prepared, and they're doing a, you know, from their standpoint, an excellent job, but it's not even been highlighted at all.
Well, in true Crossfire format, we've now transitioned to the part where we entertain comments and questions from the studio audience. That's you all, and upstairs as well. So please feel free to jump in, any of you. Yes, sir.
Several of the panel have just alluded to this aspect, especially David Crane, in saying, well, if lesser people that is, the top dog is surely due to 3,000 dead. He should be prosecuted. But what about the people who did 10 or 20? And you mentioned that it may take 5 years, or if it's 3,000 people, it may take 20 years to prosecute. Well, now that's alluding to the problem. Now I'm going to turn it around and accuse Michael Scharf of having a problem. You have created, or you're in charge of, the International Law Center. Now, you are acting under the cloak of a journalist. All you do is report other trials or other problems. You think you can stand back and say, that's all I have to do? Doesn't the creation of this organization create a duty in you to at least request and suggest prosecution of certain offenders? I think you're trying to get by as a sunshine journalist. So I think, don't you feel you have a duty to suggest prosecution?
I'm not even going to touch that. But I think if you look at my bio in the book, you'll see that our involvement is much, much more than just passively reporting on these issues. But you're
judges in Iraq, but that's like being an instructor. But how about the duty on you? So you have some duty, I think.
Yeah, well, we write op-ed pieces, we write books that try to put pressure on the international community to both indict people that need to be indicted and to bring to justice people that have been indicted, and that is part of our mission as well. So,
Mike, if
yes.
I can add something here. You know, to me, there are fundamental issues that we have sort of skirted in the whole of the discussion. Maybe we don't want to address them. But one of my concern is that because we have sort of rushed to judgment so fast, and because we have not pondered and thought of a lot of things, we found ourselves in trouble. Just let me give you an example. Originally, one of the proposals that I had was that instead of having a special tribunal, was to have a specialized chamber of the Baghdad Criminal Court, which could have accomplished the same, but it would have been part of the ordinary legal system. But then I advocated that we would have 4 additional chambers for lesser defendants, so that we would have one chamber specialized in the most serious of the offenders, and then other chambers deal with the less serious offenders. That, in my opinion, would have also greatly satisfied the Iraqi people, because there are a lot of, let's say, intermediate level offenders who have done a lot of harm, who were very visible, who were very well known, who seemingly will avoid and evade all of that responsibility. So to me, that would have been part of a better strategic approach to deal with a much larger number of offenders than we now have. And by having 5 chambers working simultaneously, depending upon the category of offenders, we would have probably been able to move faster. The other side, the flip side of the coin is, where are you going to find the judges and the prosecutors, the personnel, and the security issues? So that was the other side of the coin. So there were a lot of factors that had to be weighed, but truly, if you haven't been there, you don't realize how the security issue is a pall on everything. I mean, it's just so difficult to, if you work exclusively in the green zone, you're totally abstracted as if you were, on Mars or Venus. and going in and out is very difficult. If you're outside the green zone, it's almost an impossible task. The situation is not really very conducive to it, which sort of gets us back to one of the questions that we had before: where do we go? You know? And it was an impossible choice, because you couldn't go outside the green zone and say in the middle of the desert in Iraq and set up a judicial camp, because you need to bring too many people back and forth and they would have been targets. You couldn't take it outside of Iraq because the Iraqi people and the judges and all of the politicians thought that this would be an insult to their national dignity. They wanted it in Iraq. So, you know, if you can't look at it exclusively from one perspective, even though there are other solutions, and you think, well, gee, we could have had 5 chambers working. Yeah, but can you actually make it work? Theoretically, yes, but these are some of the problems you really have to deal with.
Mark.
Just to go back to this gentleman's question about, you know, what level to prosecute, and I think Cherif makes a very valuable point, thinking of national or local law as a bit of a safety net that would catch lower-level folks. But truly, you know, the purpose of international criminal law is to prosecute those sort of extraordinary crimes of concern to all of us. And I think implicit in that are a certain level of higher, you know, ranked offenders. And if the focus is on that, then that seems to be a bit of a natural overlap. I mean, I think another area where I personally have a lot of anticipation of what's going to happen is what are some of these substantive judgments going to look like on matters of substantive law. Like, for example, I agree with Kevin before, you know, yeah, so Saddam's guilty, these people are guilty. But of what, right? And there may be a disconnect that emerges between popular perceptions or, you know, expectations of what the convictions would be for and what the law technically may churn out. Like, to me, it's unclear whether legal proof of the actus reus and mens rea of genocide necessarily will, you know, arise from the onfall or from, you know, these ongoing or subsequent cases that will be brought. So it'll be very interesting for me to see from this technical perspective how, you know, what type of extraordinary international criminality will actually be convicted here. But in a sense, that's also very self-referential, right? Because if people on the ground want to see a conviction and want to have justice done, then, you know, why are we siphoning that off and having this very technical, navel-gazing conversation about the growth of international criminal law? There may be a paradox there,
and let me just interject here and make an invitation to this panel, all of the other panelists, and anybody in this room, and that's this. At the end of this month, there's going to be a verdict, and a lot of us are going to spend a lot of time reading it, trying to making sense of it, maybe commenting on it in the news. I would love to have as many people as possible post essays about their critiques, their thoughts of the judgment. It can be the panelists here, it can be you all out there, it can be the students, but it'd be nice to rejuvenate the Grosjean Moment blog and get another burst of energy out of it at that moment, because I think we could come up with some historic analysis that'll be very important, and for the reasons that Mark was just mentioning. Mark Ellis, you had a comment.
Okay, go ahead.
Okay, let's go to the audience and have some other questions way back there.
I have to say this, that I think that if nothing else happens with this trial, I think it's supposed to be cathartic. So that if we discuss whether the first offense, the first small trial that's been brought against Saddam was necessary to supposedly get out the kinks of the system, it's trivializing the trial itself. This is supposed to be a cathartic experience. Now, perhaps it is for those in the Arab world, and we don't get as much coverage on our side of the world as the other side of the world does. That may be happening, but nothing seems to be occurring except for the fact that Saddam gets to grandstand, even though there has been a verdict. The other thing I want to add is that what happened to our notion of collective guilt? Didn't we already experience that from World War II and decide that an entire country can suffer once it realizes the consequences of the regime that it lived under, whether it bought into it, or whether one neighbor told on another neighbor and subjected that other neighbor to torture? And now we're talking about perhaps adjudicating civilians, more or less. We've been there. So the country has to move on. And these trials of different tiers of offenders, well, at a certain level similar to what happened in Germany, yes. But otherwise, bring it up again. The collective consciousness, collective guilt. That country suffered, and it suffered by having been influenced by evil for so many years, and it has to undo itself. But in the meantime, Saddam has to be a cathartic experience for the people who lived under its regime.
You want to respond directly to that? Go ahead.
Just very quickly, I think she makes a very good point, and I think it's Chris, right? Yeah. Also said something that resonated. Unless you've actually been in a courtroom where you see a victim who, for in some cases decades, has been oppressed, walk in as a victim and be able to look that individual that caused his life and his family's life and his country's life a living hell, and then point and say, you did this to me or my family. If it ended right there, in some ways, it's almost a bell rung. I'm being simplistic, of course. But it really is amazing, and I remember that moment when that happened, because it happened specifically to me. We would bring in victims who had never been outside of their town, and they would walk in maimed, mutilated, some of them blind, some of them not capable of walking. And when you see an individual who points, because they don't have a hand, at these individuals and say, you did this to me, and then watch them walk out with their head held high, that's justice. However we come at it from whatever direction and political perspective, at the end of the day, when you have those moments happening in a courtroom, that's what we all became lawyers for, isn't it?
Here.
Truth revealing. Truth revealing.
I didn't hear that.
In terms of sort of facilitating reconciliation and having those moments that you talked about, do you think it would be useful to have a truth commission after the trials are completed?
Well, I'm a big advocate of this. You all know this. I've done this publicly. Truth plus justice equals sustainable peace. And if it be possible to do that, that's an ideal. We were lucky in a lot of ways than anything else. We had a tribunal and a truth commission at the same time. Bill Schabas and I, a commissioner and the chief prosecutor, actually met based on that, and we were able to show that, yeah, it can be done. It honestly can be done, and I think that's very important because, again, if you've been out in the countryside in outreach programs and you stand there and people come up to you and pull on your sleeve, say, I just want to tell you what happened to me and my family, they're not going to testify in court. And so what you do is you encourage them, if possible, to go to the Truth Commission. And they did, by the thousands, to tell their story, publicly as well as privately. That's very important. Obviously, in Iraq, that's a challenge. But just for my considered judgment of having been through it, the entire process, yes, truth plus justice equals a sustainable peace. And we need to continue as we mold and shape international criminal law forward. We need to look at many alternate types of justice. And certainly, with or without a tribunal, a truth commission should not just be flushed away. It needs to be modified, adjusted, but allow the people to get up and say what happened to them. To them, that in some way is what it's all about. Because that's all they're going to. That's the only moment they'll ever have in their lives to record for history what happened to their family. And the ultimate atrocity is not being able to do that, and that family disappears in the sands of time without anybody doing or saying anything about it.
I'm going to go Marika, then Sandy, then Chris, then Craig.
I just wanted to add to that and say that the survey we carried out in 2003 clearly showed that the Iraqis would have in fact preferred or wanted to have what we would call an integrated approach to transitional justice. And it doesn't stop at the justice and truth, which I strongly believe are not mutually exclusive, but instead complementary. But I think they would have also liked to see reparations. And in terms of institutional reform, I think, in fact, now we're in an extremely negative situation in many ways with current human rights abuse, etc. And this, I think, really also puts an onus on us to situate these trials a little bit better within the debate about transitional justice more generally in Iraq, and to be a bit more critical about the focus on this trial and whether that's, something that's assisted a more sequenced and perhaps a more comprehensive approach. And so if any of the panelists have reflections on that, I would be very grateful.
Yeah, in fact, I mean, there was a look at a much more holistic approach early on, and many people, including Dr. Mohammed Ihsan, who's the human rights minister from Erbil, and many other prominent Iraqis talked about the need for a truth-revealing process, where truth and reconciliation was more problematic because, again, it was a question of forgiveness, whereas compensation may have been more preferred for. It was looked at. I think Iraqis may welcome it. It's just been a question of organizing it in a timely manner. The Ministry of Human Rights has taken a look at taking actions, and during the process of establishing themselves as a ministry, it hasn't necessarily been their only priority in addition to mass graves and working on current human rights issues in Iraq. So I think it's certainly open. I think it's something they may want for the future. But importantly, efforts such as Professor Bassiouni's sort of oral history project that's going on, the Iraqi documentation project that's been going on through Kanan Makia and the Iraq Foundation and others in Iraq, are one way of having this sort of a truth revealing system, which is through a museum and a documentation project. What you may not get is the ability to talk in front of a screen or in front of a televised proceeding, which people may be not ready to do yet anyway. But it does give you a process to go in, access the historical record, learn about what happened, get it in the history books, and make it part of their history while recognizing the important point that at some point they do really need to move on. I mean, you don't want everyone living forever in what happened, but there has to be sort of all of it. So a holistic approach is definitely the way to go.
Okay, Chris Reed. Wait, hold on.
He's covered most of the points, but we have pondered and thought about all of these issues. We ponder and think about these issues on a daily basis and talk to the Iraqi government and the IHT about them. Sandy's talked about some of the things that have come up. My personal belief is that it's going to work something like this. There's going to be trials of the high-level people in the major cases. And after the first couple of those trials, there's going to be a confidence level that's built up in people that will allow them to move on to the discussions that we've only been able to touch on. And what we always said when we had these conversations was, I know we're not ready for you to make a decision about this now, but just think about it. This is going to be coming. And what I think it's too early until the Iraqi people see, hey, you know what, this process is working. There has been justice done. And I think that's true of a lot of other issues we've talked about. When we say, does having the daily televised, proceedings, is that a good thing or a bad thing? Well, in the short term, it causes a lot of pain. We're not going to know until we've got this process is done. We've got an Dujail verdict. We've got an Anfal verdict. And now people can say, well, okay, it's the morning after. Are we glad we didn't use the Ceausescu solution, but we actually had a real trial that we can be proud of? And I think that the answers are going to be positive on those questions. And I think that then, and we've talked about this, there's going to be a second level of people there, camp commandants, who we know and we've identified. But we can't have them sitting in jail for 4 years while while everyone's figuring out what's going to happen. There's going to be a process for that group. And then there's maybe a process for another group. And then there's going to be, at some level, a process of reparations. And I can say that in the investigative process in the Anfal case, and there's a little bit more permissive environment up in the Kurdish region, the investigative judges really, and this drove me crazy because from the American system, you're like, let's get the story, find our best witnesses who have the most firsthand knowledge, and bring that in. When an Iraqi investigative judge showed up in a particular collective camp or a town and basically hung up their shingle and said, I'm here, they felt that they were obligated to hear everybody's story who wanted to talk to them. And it really was a great cathartic process for people because the whole town would line up. And some people would come in and say, I wasn't around, but my cousin, this happened to my... And it was still important. And the Iraqi judges were very patient and just sat there. And it was frustrating for me sometimes because I'm like, hey, there's another town here that's got some really good witnesses. But I think it was an important part of the process.
Craig, back there.
Yes, thank you. My question has to do with considering the fact that we are talking about what's arguably one of the trials of the century, that's the theme of today, and the grandiose concept of justice, which we all believe in, and that brings us here today. Is it okay that as precedent for this court that we're talking about and for the international community that we have this trial constitute justice, considering it has had the problems that we've all expounded upon today. To have this say that this trial was proper and just, even knowing it's not a sham per se, but there are some technical problems considering, in America, and I know it's a different legal system, but if we have, considerable problems at a lower court level on appeal, those things are going to certainly be taken into consideration by the appellate court as saying, these problems get remanded for a new trial or what have you, and also considering that we do have these problems that have been expounded upon today, is it possible that the appellate, the appellate division of the tribunal will hold the trial court accountable for them? And I'm just curious about that. I mean, we've had these debates, and I was just curious if this panel can comment on that.
Well, the Yugoslavia Tribunal and the Rwanda Tribunal have, at times, reversed even genocide convictions when they've decided that they're procedural errors. The judges that are on the trial chamber, we only see the one presiding judge, but there are 5 altogether. Then there are 9 on the appeals chamber. And typically of Iraqi judges, they're very independent-minded. They're a little bit competitive. It, to me, would not be unforeseeable that the appeals chamber, if they found reversible error, would so rule. Now, in a case like Saddam Hussein, obviously there's a lot of pressure on the tribunal not to do that, and it's the same thing, though, with the Yugoslavia Tribunal and the Rwanda Tribunal, and sometimes they do, but I'd be interested in what you all think. Yeah.
I would doubt very much. I mean, I would ready to take book on the fact that there's not going to be a reversal. But maybe, again, it's difficult sometimes unless you put it in context. You really have to know who the judges are, what are their backgrounds. Some of them are former practicing attorneys. They all obviously have displayed a great deal of moral courage by accepting that position, which they knew carried a bit of an implicit death sentence, and they've acted in a very courageous way. I have to tell you that having spent 10 days with them, even though I greatly admire them and appreciate their work, I can't say that my level of personal admiration for them is the same with respect to their diligence and their desire to read and learn and acquire greater skills in their function. And I think this is a reflection of what the street also feels. I mean, there isn't a single person in Iraq that doesn't know of dozens of horror stories about what this regime did for 30 years. So this is not so much about establishing facts which are in doubt or facts which are unknown. Remember, this is an oral tradition society. People pass on stories. You don't need CNN. Almost everybody knows about the terrible horror stories. So the question is, what does this accomplish? It accomplishes 2 things in their minds. One is it puts these bad guys who thought of themselves as gods in the box. It allows the ordinary person who comes from Suleimaniya, where you were, Chris, or anywhere else, and points the finger and said, you're the bad guy, you did this bad thing. There are a number of, if you will, expectations that the Iraqi people have, which may be totally different from expectations in the United States or in the West. And I can assure you, totally different expectations of the great international lawyers. Theirs is entirely different in the sense that they want to, if I can use the word, humiliate Saddam and the leadership. They want to bring him down from the level in which he was. They want to show that finally his day has come. And they do want the catharsis that you mentioned, which hasn't occurred except, and that's most particular in the Kurdish areas. I haven't seen any of that yet in the Shia or in the Sunni areas, based on the interviews of the people that we have in the field. I'm sure it would happen, but it hasn't happened, and the politics that exist in the Iraqi arena are such that there is another risk we haven't spoken of, and the risk of the politics of victimization. The Kurds want to prove that they've been victimized to justify their autonomy. The Shia want to prove that they've been victimized in order to prove their majority control. Both of them, the Kurds and the Shias, want to make sure the Sunnis are going to stay out of power. The Sunnis are saying you're using that against us because we too have been victimized and now we are reduced to being the underdogs. So these expectations and the perceptions are being shaped by these politics as well as by the realities of life that are still very harsh. 4 or 5 hours a day of water, 4 or 5 hours every day of electricity, 8 to 10 hours standing in line to get gasoline, civilian life is totally destroyed. All of these things have an impact on what people expect and how people perceive it. Our discussions here, honestly, forgive me for saying that, would be almost substantially irrelevant for the people on the street in any of the major cities in Iraq. But not the substance of what we're saying. That is, the substance of what we're saying, which is the achievement of justice, is precisely what they want. To them, the success of these trials means much more than what we international law thinks we're. To us, it's another precedent. It's another building block in international criminal justice. To them, it's fundamental for moving on, for rebuilding their country, and for moving beyond. And that's why we owe them as much support as we possibly can. And rather than saying, hey, you guys have done a lousy job and this is almost a sham by international standards, let's see how we can help them fix the problem.
Well, I think that's a good note to close this panel. Don't clap yet. I notice a lot of very tired looks out there, and so I've just gotten a high sign. Well,
that's for us to get to the standing.
Oh, for you, but I was notified that we can begin our hors d'oeuvres and cocktails at 5 instead of 5:15. So what I propose that we do, exercising chair's privilege, is that we move right now into a 15-minute discussion, group discussion of whether the Saddam trial should be listed as among the top trials, the most important trials of all time. And let's also clap for our departing panelists. So let me suggest that there are many different criteria that people might look at to answer this question. If it's based on the significance of the defendant, well, Saddam is pretty significant. The world knows of him. The world, through the UN, fought against him in '91. There's been a huge amount of media coverage, as we've heard. He's probably somewhere up there with the great leaders that have been prosecuted in history. Or is it based on the historic precedent? This isn't an international trial. It's a mix of Iraqi jurisprudence. The decisions may not always be the best decisions as far as precedential value. Or is it about fairness? Can you not have a historically great trial if it's a historically unfair trial? So let me open it up for your thoughts on whether this is among the world's most historic trials, the trials of the century, and what criteria you think the trial should be judged on. And if you'll keep your comments short, anybody in the room is welcome to chime in. Very interested in your thoughts. Yes, sir.
I had occasion to look at your handout here, and there's a English translation of the 2005 IHT statute, and they go from Part 2, Crimes Against Humanity, and War Crimes, and it spells out everything. Now, that was passed by the Iraqi legislature, is that right?
That's correct.
Well, I want to ask you, inasmuch as there is a vagueness in the Geneva Convention, I wonder if there's any vagueness in this Part 2 and Part 3 on war crimes. You advise the court on this, I hope.
There's one interesting provision in the statute, and it's the only domestic court in the world that has this provision. It says that the court will be guided by international precedent, and that means all of the hundreds of cases that have been litigated by these other international tribunals in the last 10 years are going to guide the court in interpreting those laws. In addition, there's a document called the Elements of Crime document, which I don't think is in the packet, but which spells out the elements of each crime in much more detail than in the Geneva Conventions. It was created for the International Criminal Court, and it has been imported by this tribunal as well. It's an interesting point, though, because what it indicates as being the only court in the world that is going to be guided by international jurisprudence, that's novel. That's precedent setting, and is that one of the criteria for deciding that this is a significant court?
That was a definition then, as far as what torture is, that definition, is that similar to the definition that Congress just gave us in the last legislation they passed?
The definition of torture as part of the Geneva Conventions in Common Article 3? Is that what you're asking? Is it the same Common Article 3 that the Supreme Court in Hamdan said the Congress just litigated or just legislated on? Is that the question? Yeah. Does anybody want to?
Mike, let me point out to you and to everybody else the definitions of the crimes taken out of the ICC statute is unquestionably a violation of the principle of legality. It violates the Iraqi constitution. It violates the Iraqi criminal code. You cannot just simply go and pick up something which is in a statute, which is a treaty that has been negotiated between parties to a treaty, and incorporate that upon a domestic legal system. The Iraqi legal system is the same as, I would say, 2/3 of the world's legal system. This is a violation of ex post facto. It violates the basic principle, no crime without law, no penalty without law. So that has to be very clearly understood. And the problem is that we could have found a different way to do it. We could have fudged it by saying, we'll take the Genocide Convention as is because Iraq ratified it. We'll take the provisions of the grave breaches and incorporate it because Iraq ratified it. We cannot really rely on crimes against humanity. We should have then taken the provisions of the 1969 Criminal Code, which has the murders and the manslaughters and the whatnot. The problem of violating the principles of legality is something that I don't think can be cured, even though the Iraqi legislature enacted the IHT as a substitute to the IST, because then it's an ex post facto application which the Constitution prohibits. And that's one of the fundamental problems of legitimacy, which is going to hound the legacy of the tribunal and as well as its legitimacy.
You know, we actually discussed this at length during the training sessions, and I'm wondering if Mike Newton would comment on that.
Well, I'll just say that was not a problem that was unrecognized or a problem that Iraqi jurists didn't care about because, as was pointed out earlier, very positivistic legal system. I think it's even the first article of the Iraqi Penal Code, or the Code of Criminal Procedure. You know, that lays out that positivistic principle of legality. Lots of discussions about that. I think that'll be probably the most important section of the Dujail judgment addressing that issue, and which gets at the overarching legality of the court. I will say that a lot of the thinking in Iraqi jurists' minds was that they, and I've said this before, they saw this process, not just on behalf of the Iraqi people, but to the wider region, as being one embodying relevant international standards. And therefore, they said, we want to incorporate the appropriate, current, relevant international standard to the degree that we can and think and learn and practice in those terms. That's why the statute simply says they'll be advised by, they'll consult other jurisdictions. But that's the level to which they wanted to learn and wanted to apply themselves.
Mike, this is completely contrary to the Constitution and law. It would be against the law of the United Kingdom, of Germany, of France. Name any European country. You just can't come up and say, well, there is something called an international standard, and we're going to rely on the elements of crime of the ICC. You know, these countries have constitutions, they have a legal process. The legal process requires that you enact the law, that the law that is being enacted is clear and unambiguous, it doesn't have a retroactive effect, and it provides for a penalty. The problem is that they were so influenced by their American advisors that this is what they had to do, that they bought it. And the American advisors didn't have the flexibility and sufficient understanding of how to massage the Iraqi legal system to come out with the same result without imposing that external international standard.
Can I ask you a question? The Covenant on Civil and Political Rights, which Iraq has ratified, has this provision that's an exception to this area for the Nuremberg precedent, for crimes against humanity. Why is it that you're suggesting that? Sure.
The International Covenant have a very specific clause that says you cannot violate the principles of legality. That I know of.
And then there's another provision that says that you can't argue that with respect to crimes against humanity and Nuremberg and that whole precedent.
Not that I know of.
Do you want to chime in on
Not
that?
that I know of.
Well, you're talking about Article 15 of the Covenant on Civil and Political Rights, and it just makes a rule that you can't prosecute, that it's contrary to the Covenant to prosecute someone for a crime that didn't exist in their national law or under international law. And that's what it's
under international
or under international law. And so that's used in some countries, for example, that prosecute Nazi war criminals for crimes against humanity, fall back on that. Of course, we know that we're still debating about crimes against humanity in 1945 as to whether that was retroactive prosecution. And in fact, the Nuremberg judgment that everybody's commemorating this week doesn't really resolve it either, because it says, well, maybe it is retroactive, but the rule against retroactivity is a rule of justice, and it would be unjust to let them go free. So I don't know about that. I wanted to respond to your more general question.
Please, and that'll be, I think you're going to have
and then
a
I'll stop.
comment.
Yeah, this will be my last words, okay? But about what makes a great trial and a great judgment. First of all, let's distinguish the judgment from the trial. Some of you talk as if you know what's in the judgment already. Didn't you get that impression? I don't know. I mean,
that's a very important point, because I don't particularly appreciate the undertone that somebody's written a judgment already. They're working on it. Nobody knows what it says.
I don't know if you.
In fact, the reality is
I wasn't suggesting that, Mike. Come on.
That look, there were pretrial motions made.
Yeah.
The court responded to a couple of those in writing and went completely unreported, completely bypassed. When they did do what a lot of us wanted them to do, particularly from the West, it was completely unnoticed. But so everybody criticized, they have to respond to these things. And what the court said from the bench over and over and over again with regard to the legality in particular and the legitimacy motion is, yeah, that's right. It will be a major part of the judgment. We will justify this in the judgment. That's why I made the comment.
Okay.
Because I think this is the most important part of the judgment, both for our purposes and for the purposes of the Iraqi people. I mean, if you have those laborious trial motions made that are actually sort of bypassed or glossed over or ignored in the judgment, then I think you have a serious fundamental fair trial
but
problem.
Michael Scharf seems to even know how many pages there are in the judgment.
No, I was, you know, actually, we talked during the training sessions, the judges said, how long do we have to write one of these opinions?
Yeah.
And we showed them the opinions from the international tribunals, and they said, does it have to be that long? And we explained, actually, that you do have to make findings of fact on every element for every defendant, and you have to have conclusions of law. There has to be analysis, and you can't do it in just a couple of pages.
There's a nice judgment from the International Criminal Tribunal for Rwanda that came out about 2 weeks ago. And, 70 pages. I heaved such a sigh of relief that they're finally getting the message that the judgments don't have to be 600 pages long. And it's actually not bad. But I guess for the judgment, we can't say. Now, it may be a lousy judgment, it may be a great judgment. And the same for the appeal. We get good judgments and bad judgments from the judges at the Yugoslavian and Rwanda tribunals, and we've had some doubtful judgments from the judges at the Special Court for Sierra Leone, have we not, David? And some good ones as well. So it's, I guess it's just too early to tell. Is it a matter of the importance of the defendant? If that were the case, then I guess the trial of Ceausescu would be a great trial. or the trial of, wasn't Marie Antoinette? Wasn't there a trial of Marie Antoinette and Louis XVI? That'd be a great trial as well, just because of it can't just be the importance of them. I think sometimes you have great trials where the judgments actually aren't that interesting. Frankly, the great Nuremberg trial, the judgment isn't that great. When all is said and done, there's a lot of facts in it. It tells you the story of the Nazi aggression. In terms of law, it's not that important. And you could see this in the case law of the ad hoc tribunals. They draw much more from the lesser trials that were held. And some of the national war crimes trials, but above all, the successor trials that were held in Nuremberg. We all know the great one that's in the film Judgment at Nuremberg. But some of the other ones, rather than the trial of the International Military Tribunal, which actually left I think, very little in terms of law, actually, in terms of significant precedent. And then finally, there's this issue that you mentioned about following the international standards. It may be in the Iraqi law that they're to follow international case law, but in the rare examples we have, we don't have that many, but whenever international crimes are prosecuted by national courts, they look to the international authorities. So this will not be, if they refer to the precedents of the Yugoslavian Rwanda tribunals, this will not be the first time that that's happened. There's a great judgment of the Supreme Court of Canada last year in the Mugesera case, which is on crimes against humanity, and they refer to the evolving case law of the tribunals. They talk about how the Yugoslavia tribunal has removed the plan or policy element from the crimes against humanity, and even a nod of respect to our colleague Cherif. They say, he takes the opposite position, but maybe the law will evolve more towards his view. It's like a very sophisticated discussion of it. So it's certainly not the first time that the judgments of the ad hoc tribunals will be referred to by national courts either. So, let's wait and see. Maybe it'll be a brilliant judgment, and maybe it'll be a piece of
all right,
not
so
such an interesting.
Before we adjourn, I'm going to have Mark Ellis do the very final word.
Michael, I was just going to respond to Bill and say that I think this judgment, the jail judgment, will be important and is absolutely crucial for one reason, because of the weaknesses that existed in the trial process. And I think the judgment has an opportunity to redeem the trial process. And that's why I think, particularly as in the long term, the judgment is going to be absolutely crucial in judging the effectiveness and fairness of this tribunal.
Well, let me close then with a few final words and a thanks to the panel. The final words are this. First of all, the audience has been terrific today and upstairs as well. It's been a long day. Our brains are full of thoughts. But I think that a lot of what was discussed here is going to be, one way or another, digested and put into the public domain through the blog, through our writings, through essays, through our commentary on court TV or wherever, and also through our contacts in Baghdad. So it isn't that this is just a purely academic exercise. We may be actually contributing something substantial and good to this process, and that was my hope. And then the second thing I want to do is to thank the panelists. This is really an extremely high-powered panel. We have government officials. We have some of the greatest lights in the field of international law and international criminal law. They've come from all over the world, as far away as Auckland, Arusha, Tanzania, England, Scotland, and you're all here because we all are committed to the idea of international justice. Whichever side you were on that debate, we all want the same thing at the end. And I just want to thank all the panelists so much for coming here. Thank you. There are hors d'oeuvres and cocktails outside in the rotunda, and you get a chance to mingle and ask questions of your panelists and friends. Thank you.
Thank you.